Today, the subcommittee examines legislation that I've introduced along with the distinguished chairman of the full committee, with Representative Tom Petri, and with several other members of the committee, that would codify uniform standards for dealing with claims of a state secrets privilege by the government in civil litigation. In the last Congress, we had an oversight hearing on the state secrets privilege and a hearing on this legislation. The bill was reported favorably to the full committee. Our experience has demonstrated the destructive impact that sweeping claims of privilege and secrecy can have on our nation. In order for the rule of law to have any meaning, individual liberties and rights must be enforceable in our courts. Separation of powers concerns are at their highest with regard to secret executive branch conduct, and the government simply cannot be allowed to hide behind unexamined claims of secrecy and become the final arbiter of its own conduct. Yet claims of secrecy have been used to conceal matters from Congress, even though members have the security clearance necessary to be briefed in an appropriately secure setting. That has been the case with respect to the use of torture, with the use of illegal spying on Americans, and other matters of tremendous national importance. And let me add here that this issue is perhaps the most important issue, in my judgment, this committee will face, because this committee is charged with enforcing civil rights and civil liberties under our Constitution. And there's an ancient maxim of law that says there is no right without a remedy. And if the government violates your right, if it kidnaps you, it tortures you, it deliberately burns down your house, it wiretaps you without a warrant, whatever, how do you enforce your right, how do you enforce your right against the government? Well, the administration could criminally prosecute its own members who have done so. That's unlikely. Congress could exercise oversight. That's hit or miss. Or the victim can sue in tort, can sue the government for illegal wiretapping, for kidnapping, for intentional infliction of mental distress, for assault, whatever. But if the government can eliminate that lawsuit on the pleadings, simply by coming into court and using the magic incantation of the word state secrets and say this case should be dismissed because we say on our unexamined assertion that trying the case would necessitate the revelation of state secrets, case dismissed, then there is no recourse to the courts and there is no enforcement of rights, and rights without a remedy are illusory, and we have no rights. Therefore, we must put some limits on this use of the state's doctrine. The same pattern of resorting to extravagant state secrets claims has been evident in the courts. While the Bush administration did not invent the use of the state secrets privilege to conceal wrongdoing, it certainly perfected the art. The state secrets privilege has been abused by prior administrations to protect officials who have behaved illegally or improperly, or simply in an embarrassing manner, rather than to protect the safety and security of the nation. The landmark case in the field, U.S. versus Reynolds, is a perfect case in point. The widows of 3 civilian engineers sued the government for negligence stemming from a fatal air crash. The government refused to produce the accident report, even refusing to provide it to the court to review, claiming it would reveal sensitive state secrets that would endanger national security. The Supreme Court concurred without ever looking behind the government's unsupported assertion that national security was involved. Half a century later, the report was found, now declassified, online by the daughter of one of the engineers, and it clearly revealed no state secrets. It clearly could have been made available in a form that would have enabled those families to vindicate their rights in court. It did, however, reveal that the crash was caused by government negligence, which I suspect was the real reason for the invocation or the invention, in that case, of the state secrets doctrine. Protecting the government from embarrassment and civil liability, not protecting national security, was the real reason for withholding the accident report. Yet these families were denied justice because the Supreme Court never looked behind the government's false claim to determine whether it was valid. Similarly, in the Pentagon Papers case, then Solicitor General Erwin Griswold warned the Supreme Court that publication of the information would pose a grave and immediate danger to national security. 18 years later, he acknowledged that he had never seen, quote, any trace of a threat to the national security, unquote, from the publication of the information, and further admitted that, quote, the principal concern is not with national security, but rather with government embarrassment of one sort or another, close quote. It is important to protect national security, and sometimes our courts have to balance the need for individual justice with national security considerations. Congress has in the past balanced these important, albeit sometimes competing, demands. In the criminal context, we enacted the Classified Information Procedure Act. In FISA, we set out procedures for the courts to examine sensitive materials. Through the Freedom of Information Act, we sought to limit any withholding of information from the public whom the government is supposed to serve. We can and should do the same in civil cases. Our system of government and our legal system have never relied on taking assurances at face value. The courts and the Congress have a duty to look behind what this administration or any administration says to determine whether or not those assurances are well-founded. Presidents and other government officials have been known not to tell the truth on occasion, especially when it is in their interest to conceal something. The founders of this nation knew that there needed to be checks in each branch of the government to prevent such abuses from taking place. Or in the words of the Ninth Circuit in the recent Jepson decision, the executive cannot be its own judge. To allow that, and these are now my words, to allow that is to abandon all the protections against tyranny that our founding fathers established. Courts have a duty to protect national security secrets, but they also have a duty to make an independent judgment as to whether state secrets claims have any merit. When the government itself is a party, the court cannot allow it to become the final arbiter of its own case. The purpose of this legislation is to ensure that the correct balance is struck. I would just add that I am extremely disappointed that the Department of Justice has declined to provide a witness to discuss this very important issue at this hearing. I have met with the Attorney General, and I understand that a review of this policy is currently underway. Nonetheless, the Department continues to go into court while this review is underway and take positions that are remarkably similar to positions taken by the last administration. While I greatly appreciate the Attorney General's willingness to work with us, I believe that it should be possible to send someone to provide us with the administration's views and to answer our questions to the extent that they are able. I hope this is not a sign of things to come. I look forward to the testimony of our witnesses.